Welcome to Trust Me, It's Complicated, Decoding Estate Planning, Probate, and Trusts with attorney John Marshall.
Welcome to Trust Me, It's Complicated with me, your host, John Marshall, the show where we make estate planning feel less overwhelming and more empowering to you. Today, I want to talk about some different aspects of estate planning that come up in my office with clients who have just moved to Florida. See, I always like to tell people, this is Florida. It's not California. It's not Ohio. It's not New York. This is a completely different environment. It is a different environment from environmental standpoints, from animal standpoints. Don't touch the gators. Leave them alone. They'll leave you alone. But also from a legal standpoint. And when you are a resident of another state and you have an estate plan, and now you've said, hey, I'm going to move to Florida, we need to revisit that estate plan because things are going to be different here. So the first thing that I want to touch on that is different now that you are in Florida is ownership by a married couple, whether, same sex, opposite sex, but ownership by a married couple is called tenants by the entirety. And tenants by the entirety means joint tenants with rights of survivorship, except with the combination of marriage. So I can own a property with my brother and have it joint tenants with rights of survivorship. I die, he owns it, he dies, I own it. But I can only have tenants by the entirety ownership with my wife. Now, why is that important? Well, yes, I want her to inherit if I were to pass away first. But secondly, tenant by the entirety property is exempt from the claims of your individual creditors. So think about this. I die, I have a credit card bill. My wife doesn't have to pay it. She owns everything now. She can literally walk away from that. I drive a Toyota 4Runner. I like it. In fact, I want to raise it. My wife thinks it's already high enough, it doesn't need to go up any higher. Yes, it does, and I will enjoy it. But here's the deal. If I still owe money on that 4Runner and I die, my wife can call Toyota up and say, come take it away. I don't want it. And they take it and they say, well, John still owes X number of dollars on it. And she says, I don't owe it. And legally, they cannot collect. And that's because the second I die, she owns everything. She does not owe my debts. And that applies at death and during life. So let's say I'm at the range. I'm an idiot and I don't check my gun and I discharge and I shoot the guy in the lane next to me. Okay. I am liable for that. He has every right to sue me. But guess what? He cannot come after any assets I own jointly with my wife because I am liable for that issue, not her. So with tenants by the entirety, we want ownership by husband and wife because we get protection from the claims of our individual creditors. Now, if they have a joint creditor, those assets are not protected from the joint creditor. And that's why I tell spouses when you move to Florida, own your assets jointly, own your debts separately as much as possible. Now, a mortgage, you're probably going to carry that as a joint debt. But if you can avoid joint debts on credit cards, on car loans, on different things like that, do so. So again, we want to protect assets through the ownership of a married couple using tenants by the entirety. Great benefits while you're alive, great benefits even in death. Now, part of the problem that we run into is you can lose tenants by the entirety if your trust owns those assets. And that's because the courts have said, look, ownership by a trust, even if the two trustees are married, is not ownership by husband and wife or a married couple. And the reason for that is one of those trustees could be replaced at any moment. I can create a trust. I'm the grantor. I'm the one who's making the trust, and I can be the trustee. But I can also be the grantor and name someone else as the trustee. So if I'm the grantor along with my wife, she's the trustee, and I name my brother as the other trustee, guess what? That's not tenants by the entirety. So to own assets tenants by the entirety, you have to own it as a married couple outside of your trust, which is oftentimes why I counsel clients, if you have a trust, and we do a lot of trusts here. So if you have a trust, own your asset jointly, but make it pay on death to the trust. And we do that with a lot of property. We use ladybird deeds, and we'll talk about that in another podcast. We'll use beneficiary designations at the banks or with financial firms to make assets payable to the trust upon death, so that if both spouses died in a common accident, it's paid in the trust, it bypasses probate, and we get the benefits of the trust, but we still get that tenants by the entirety while both spouses are alive. Now, that's all to deal with most of your other property. But now we're going to switch over to something that's really very unique to Florida, and that is homestead. So when you buy a home in Florida, the realtor may or may not mention to you this idea of homestead. But usually what you're told when you're buying a property is, hey, you need to file for the homestead exemption from ad valorem taxes, property taxes, and that's about it. There's very little that people actually hear about it. And it's not uncommon for me to sit down with a couple that's maybe lived in Florida 2, 3, 4 years, own a home here, and I say to them, hey, I looked at your deed, I looked at your property appraiser report, I don't see the homestead exemption. And they look at me and say, well, I don't know what you're talking about. So here it is. Under Florida law, if you register your home with the county, you must own the home by January 1st, and you must register by March 1st. You will get the homestead exemption on your property. And here's how this works. It's a $50,000 deduction on the tax value of your house. The first $25,000 is exempt from all taxes. So any property associated tax, the first $25,000 is waived. The next $25,000 of the home value is subject to all taxes, but then the next $25,000 is exempt from all taxes other than school taxes. And I got to tell you, even here in Florida, we actually spend less on school taxes than most other states, and yet our performance continues to raise. Again, a testament to the amazing job that our governor has done here in Florida. So shout out to Ron DeSantis. But the point of this is there is a $50,000 deduction on your homestead property if you file with the county. And that $50,000 deduction is not a something just small. It can reduce your tax bill by thousands of dollars. Now, the second aspect of filing for homestead is called the Save Our Homes Initiative. And this is also very important. Right now, home values are moving up a little bit, but they're not climbing a whole lot. And right now, everybody kind of admits it's kind of a stagnant market. And that could change. That could change almost overnight. Depends on what happens with interest rates. But over the next few years, we do anticipate that interest rates will drop, especially if Jerome Powell leaves the Fed and Donald Trump were to appoint a new chairman of the Fed. We expect rates will drop. And likely at that point in time, we will start to see an increase in sales of homes here in Florida and likely another rise in home values. Now, the Save Your Home Initiative says, despite what the value of properties may be doing in the local market, your homestead property cannot go up in value by more than 3%. So if the local market, the value has gone up by 1%, the property appraiser can raise the value of your home 1% for tax purposes. But if the value of your home, based upon what's happening in the market, has gone up 5%, they cannot raise the tax value in your home by more than 3%. So that's why if you look at a home that somebody has owned in Florida for 20 or 30 years, the actual value on their home may be up, quite a bit, whereas the tax value is really low. And it's because of the combination of the $50,000 deduction on property taxes along with the Save Our Homes cap of 3%. But again, you have to own the home by January 1st, and you must file with the county property appraiser by March 1st. Now, here's the thing. It used to be that you had to do the application by paper. The nice thing about this modern era that we're in is that you can file a lot of this online. So we are currently in the process, my wife and I, of buying a new home. As soon as we close on that home, we are going to begin the process of filing for the homestead exemption, even though it won't be processed until March of 2026. And the reason for that is we want to get that application in so that as soon as the homestead exemption can be applied, it will be applied and we will get that reduced tax value. And that's important because when you are buying a home, and you look at the tax value in that property, what you have to keep in mind is the Saver Homes initiative is in effect. So the value of the home has been capped at how quickly it can grow. But when you buy the property, it gets reassessed to the current market value. So you may see a home that has a tax value of 250,000, but you're buying it for 500. The property appraiser is going to reassess it to 500. So getting that, that Saver Homes initiative and that $50,000 deduction on there is very important, and you want to apply for that as quickly as you possibly can. Now, that is what we call statutory homestead, because those deductions are found in the Florida statutes, more specifically sections 196.031 and 193.155. And if you think I knew that off the top of my head, no, I do not. I have it here on the screen next to me. Even I have to look up the statutes. There's too many of them to keep track of. However, there is one statute that I know off the top of my head. It's actually not a statute. It is Section 10, Article 4 of the Florida Constitution. And in that section of the Florida Constitution, it talks about your homestead property. And as your homestead property, there is a very important benefit that you get. And it doesn't matter if you're married, if you're single, if you're sharing the home with someone else, doesn't matter. If it is your primary residence, your homestead property is exempt from the claims of creditors other than the IRS, because it's the IRS that can do anything. The state of Florida, if you don't pay your property tax, they can do tax deed sales. And actually, it's a little bit more complex than that, but you have to pay your property tax. A secured lien holder, if you take out a mortgage on the property, they now have a secured lien against your home. If you don't pay the mortgage, they can foreclose. Also, if you have HOA dues that you don't pay, they can secure a lien against your home. Or let's say you have a roof replaced and they file a mechanic's lien on your home until their bill is paid. That is also permitted. However, even in those issues where it's permitted, they are limited to certain timeframes in which they can file. But all other creditors cannot go against your home. If you have a car accident that you are liable for and you don't have enough insurance, they cannot come after your home. If you don't pay your debts, like your credit card debt, and they sue you and they get a judgment against you, they cannot attach that judgment to your home. And that is a very, very nice benefit. And you do not have to file for this. It is automatic. The second you purchase your home and you move into that property, it is your homestead property. See, when we bought our home back in 2018, I made sure to drop off a sleeping bag, clothes, and I slept the first night in that property. Why? It was my homestead property. The rights that I just described about the exemption from creditor claims immediately attached. Now, here's where it gets a little bit weird. If you are inside the city limits, the homestead exemption is limited to a 1/2 acre lot of land. Okay, now, again, if you live in the city limits, having a 1/2 acre lot actually is a pretty good size. There's not many that are really, larger than that. But if they are larger, again, the exemption is applied pro rata to the value of the property. But if you are outside the city limits, the homestead exemption can be up to 160 acres. So I have several clients that own a lot of land that they live on. That's their primary home, is on maybe an acre of land, but they own 100 acres around them. The other 100 acres falls under that homestead exemption. And it's a beautiful exemption because, again, it was designed to help preserve family farms and different things like that that are important to our economy here in Florida. And yes, we have a large farming communities throughout the state. So again, we have some nice protections there. And what's really nice about this is all of this comes under the Constitution of the state of Florida. So if the legislature decides that they want to do something weird or funky with that, they can't. It's a constitutional amendment. So they would have to go through and have the amendment modified by 60% vote of the people of Florida. And that's not an easy thing to pass. So again, and look, let me tell you, I don't want anybody messing with my homestead property. So anybody try to pass something that's going to modify that amendment under the Florida Constitution, unless it's to make it stronger, many of us are not going to support that, because that is our home, that is our castle, and that is protected very strongly by the Constitution here. In fact, the protection is so strong that Florida's Medicaid system cannot pursue collecting that home after you die to pay their debts. So they can't force the family to sell it, to collect it, nothing like that. So let me give you an example. I had a lady a few years ago. She passed away tragically. She had inherited a home from her father. She lived in that home, but she traveled a lot. She actually worked overseas. But that home was where she stayed when she wasn't working abroad. That was her primary residence. She died. But when she died, she was actually in New Jersey getting care. And so what happened is an attorney up there says, well, she's a New Jersey resident, so we're going to open up her estate here. And she had $500,000 in debts, all of it medical related to her cancer treatments. And the family was going to lose everything. And I stepped in and I said, well, wait a minute, hold on. The asset that we're talking about, that's her home here in Florida, right? They said, yes, we're going to have to sell the house. We're going to have to pay this. I go, oh, stop. It's her homestead property. It's protected. So I got the family in touch with a new attorney in New Jersey. We dismissed the probate case up there because she wasn't a New Jersey resident. That's where she died. She was a Florida resident. So we opened a case in Florida. We got her home declared exempt under our Constitution. The family kept the home. The creditors got nothing. And at the end of the day, that's really what she wanted. It's not that we want to stiff creditors, but it's the homestead property. We want to protect it, and we want to pass it off to the next generation protected as well. So when you come to Florida, you need to understand a few things. One, if you're married, you want to own assets tenants by the entirety. And if you're not sure how to set that up, and most people don't know really how to make sure that they have it, meet with an attorney. People like me, we are happy to sit down, look at your assets, and give you the guidance on that to get that little bit of added creditor protection. Second, you want to file for homestead. If you have bought a home in Florida, you want to file for homestead through the property appraiser. You want to make sure that that exemption is applied to the tax value of your home and that you're getting that 3% cap. And then third, when you buy a home, stay in that home as quickly as possible, even if for a single night, but just start putting stuff in there and move in and declare that your primary residence, because that's now your homestead property and under the Constitution it's protected. So these are things to keep in mind now that you're a Florida resident. And we're going to touch on more topics about moving to Florida and things that you need to be aware of, because again, this is Florida. It's not Ohio, where I also practice law. It's not West Virginia. It's not New York. So again, very different set of laws. Thank you for listening. Thank you for coming back to Trust Me, It's Complicated. I have been your host, John Marshall. I look forward to having you back on future podcasts. And if you have any questions about estate planning, probate, guardianship, send them our way. We'll be happy to make a video addressing them. In the meantime, if you want us to talk to you about the issues that you have with your estate plan, call us at 352-432-8859 or visit us on the web at marshallawpa.com. Thank you and have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.